It's matter 261 of 2025. It's not fresh and it's matter.
What is the urgency? What is the urgency?
But for fresh admission.
Next week.
Next week, may kindly take up this matter on within 15 because after 15 I am not available here.
You are not. Are you going abroad?
No, my lord, just.
All right. Post it before 15 something.
My lord, this is a case WPC number 5. Of 12.
Take that.
13.
The 13 years
should be 16th July.
16th.
Yeah.
We are not that sure because calendar is heavily loaded now. It may fall down any time. This and that. Therefore, we'll have it in the second week of August.
Second week of August?
First week of August. Okay. Yes.
Yeah, I may be pardon, my lord. W number 2023, my lord. What happened here, my lord? We had the copy number 1, 6 and 7, my lord.
What do you want?
My lord, listing, my lord, because collector is issuing notice to eviction, my lord.
First week of August. Okay.
Another case, my lord, where
one memo, one lawyer, one memo.
Okay, my lord.
Give it. I said it by humor. Now in the second week of August. Okay.
I may be pardoned, my lord, to make a mention. This is a writ appeal number 797 of 23. The matter has been admitted on 21st.
When do you want? In the first week of
September. Listing, sir.
September. Give it. Yes.
Permission. Item number 27 of today's list.
27, my lord. No, phase 1 we shall go. We shall go. So we will go by phase 1. Yes. Starts at phase 3.
Phase 3, 10 to 17.
Yes, please. Pardon to mention. When the matter number 15, if I will observe.
You want time in that?
My lord?
Serial number 15.
My lord.
You want time?
I am for petitioner, my lord.
Correct.
Opposite party not appearing, my lord. Previous state, the lordship project. I'll give a last chance to appear for the opposite party, but she did not appear till late.
He has not come?
No, my lord.
No, wait, let us see. Right. Just try to contact also over phone. Yes. Tell him that judges are waiting. Yes.
My now item number 11. My lord, item number 11.
No, service has been done.
Yes, to be service. But the problem is these matters have to be taken in. Please don't mention orders matter. It has been orders matters
are generally not mentioned.
Without orders, then what is the point in listing and adjourning? Correct. Please appreciate.
My lord, item number 11, although it's an order matter, it is just a withdrawal. Because the matter has been
order has to be passed. Give the memo.
The memo has been already filed. The matter has been compromised.
Which one? Serial number?
Serial number 11.
11.
Any amount due to be comply with post order or the
no, my lord, that has been paid.
That is paid.
There was a mutual default.
Look into paper.
I have filed the.
We'll do that.
You can request any of your client. I mean, relatives are not there. If you are leaving the court, then you can inform any of your friends to.
Because
my friend,
we want to assert any orders.
I am the appellant.
Yes, maybe, but sometimes we make orders to the husband who is the appellant to make payment. And whether that payment is made or not, we have to ascertain.
No, I have already filed the copy of the judgment.
We will do that. Kindly wait.
Page 4, 18 to 22.
Well, item number 21. Lord, we kindly permit to adjourn to next week, my lord. Mr. Das is suffering from fever.
Is it?
Fever after the last hearing.
Again.
Fever after the last hearing. Hearing fever.
We heard this matter actually. Call this matter on next week something. Finally, at the request of Mr. Das.
Date code 18.
Yeah.
18 July.
Next week.
Page 5, 23. Page 4, 24 to 27.
Item 25, Your Lordship.
25.
Sir, I am for the appellant, Your Lordship. I pray for 1 week after.
First week of August.
All right.
Item 27, Your Lordship.
27.
In this matter, pleadings are already complete. We just want some time to get reply in the matter, Your Lordship.
Also, in the second week of August, at the request. Inform your all, you have to inform your friends.
Along with the other two matters, I am appearing for the petitioner in those two cases.
All matters are adjourned, Mr. Prabhu.
No, it's 3 matters. There are 3 matters in
You agree for adjournment?
Manoj, because that is the lead matter. If your lordship has decided, the others are decided.
Item
Greatly obliged.
Page 7, 28, 29. Page 8, 30. Page 15, 31 to 34.
Item 33, my lord. Matter into admission in BSc Nursing for the accreditation 23-24. In the meantime, it became infructuous. I am filing a memo, my lord.
Admission matter.
Admission, my lord.
34.
33,
33.
my lord.
But
I think present other side.
I have filed a counter, it has become infructuous. Counsel for the petitioner submits, and the panel counsel appearing for the opposing parties does not dispute that the matter has become infructuous. Next paragraph. In view of the above, the petition is disposed of accordingly as having become infructuous. First meetings. Memo reads as a one sentence you are carrying. Yes.
Page 16, 35 to 38.
Item 35, lordship.
35.
35, lordship. On behalf of Pierre Mishra, due to throat infection, kindly taken up.
What time? Second week of August.
My lord, 37. 37, next page 39, 40, 41. These nursing matters I mentioned, they requested my lord. I should have given some time. I have taken consent. Regarding that NOC matters.
Have you informed the other side?
Yes, my lord.
I am for the 40 item.
So appearing in 41 as petitioner, my learned friend is also in other matters.
But the urgency was they seek
my lord.
opening of that your portal for admission.
In portal admission is up to started. Again, also we have
not asking, sir. But
It is for the rejection of NOC.
Sit for a short.
This is for rejection of NOC, and the admission will be up to 30th of September. And we have also
30th of September.
So there is time, so no problem. So let it come after 1 week on 22nd on 23rd.
22nd.
22nd.
August it will go.
July.
26 July, Millard. August is the admission.
Okay, no. September 30 is the last day.
Yes,
Yes, Your Lordship. But again, after this grant of NOC, after GS,
Admission process is
after the grant of NOC, the admission.
I told him that, but both of you supported him.
No, Your Lordship.
24th we shall have.
Yes,
25th. 24th we have other matters. 25th also.
All right.
Page 17, 42 to 45, 44. Page 18, 44.
Pardon to mention, madam. Pardon to mention, madam, what WPC number 3430 of 2025, my lord, it is getting listed for 2 days now, but it is not reaching, my lord, listed next week. It's
For
Hearing matter.
yes, my lord.
25 always will go down because it's a computerized system.
Yes.
We can't
put it above.
I mean, we can't do it.
I mean, pardon, item 5 once. Item 5.
5.
It
will reach in a couple of seconds. Wait.
Item 1.
The petitioner he wants to no instruction.
No instruction.
The original matter has been disposed of.
Original matter is disposed of. Perfect. The order, no, that's not this. The order from which the main proceedings from which the impugned order emanates, comma, having been disposed of, comma, this appeal has been rendered infructuous. First one, any grievance in respect of the impugned order can be worked out when, if and when the order whereby main proceedings have been disposed of is put in challenge, comma, as provided under Order 43, Rule 1 capital A of CPC 1908, comma, as has been consistently held by us in similar matters. First one, ordered accordingly and appeal is disposed of, keeping open all contentions.
Item 5.
1 week. 1 week. 1 week. 1 week. The second week of August 2025.
Item 6.
May I please, Your Lordship?
Yes.
A judgment dated 29/10/2024 at Annexure 1 of the Honorable Single Judge is under us challenge.
Your voice should be audible to us. See how we speak. Everybody hears in our call.
The order under Annexure 1 passed by the Honorable Single Judge is under challenge in this writ appeal.
What was your complaint before the learned single judge?
Complaint that everything, natural justice and procedural niceties have been followed.
Banking.
Procedural formalities and niceties and adequacy of evidence, everything is affirmed by the Honorable Single Judge. But while saying so, he has come to a conclusion, a conclusion which is contradicted by itself. So a glance to the last portion of the order will reveal how the contradiction is very much apparent on the face of the record. Kindly, my lord.
No notice is ordered in this matter.
No.
Fresh matter. Judgment, in your submission, to put it in a sutra, the operative portion runs counter to the reasoning part.
Yes. And one thing is that while the Honorable Single Judge says that everything is followed nicely, and I am reminding them.
Not have made that.
But then he said settlement of the dues. Last para, last para of the order.
Page number?
Page 36 and 37. 36, last para.
Para 18.
Para 21. Page 36.
Look at para 18 also.
Yes, para 18. Dishonorably, the impugned order or order suffer for a lack of sufficient reasoning.
Actually, that's a typo.
Orders suffer from.
Yes. Dishonorably, the impugned order still suffer from a lack of sufficient reasoning, failing to adequately address the varied grounds presented by the parties, including allegations of procedural irregularities and substantive policy violations. Although the petitioner provided multiple justifications, the opposite parties failed to meticulously multiply.
Examine.
The justification. The opposite party failed to meticulously examine these aspects. It was incumbent upon the opposite party to deliver a well-reasoned, transparent order grounded in a thorough review of the relevant documents and evidences, especially given that the court had previously remanded the case with the explicit instruction to issue a reasoned decision.
You are leaving the very important ground of the Supreme Court, which is in your favor.
Yes.
Can we reveal it to you? That Supreme Court said there cannot be withholding of increments with retrospective effect. That ground you have not taken.
No, but
we have taken.
Here, my lord,
we have written.
Kindly see page 32.
32?
Yes.
No, anyway, we have
fairness, everything is there.
Correct.
But if you are remanding the matter for consideration to appellate authority, how can you say that settlement of the dues?
Anyway, take notice. Issue emergent notice.
The 7 days delay from the date of
emergent notice.
From the date of order. From the date of 7 days
notice, we can't control.
Both. You take notice on both.
Both on limitation and main matter.
But in the meantime, my lord, contempt has been filed and it is directed that 2 months arrears should be paid. Third para consider his case.
But you should have come, if that way to be so, you should have come.
Can you not pay
within the
without
limitation.
prejudice?
Well,
Without prejudice, you cannot pay his retained employee.
area dues, heavy dues.
You are a bank, you are a behemoth. Against you, he's pitted, he's a small employee.
No, small scale one officer.
But you should have been free. You should have been very vigilant. You can't come with delay and say that no, this will happen.
11 days delay, but no delay on the question of
The contention of learned counsel appearing for the
contempt has already been filed.
interim order needs to be granted, cannot be acceded to at this stage, since law is settled by the apex court to the effect that without condoning delay, no interim orders can be granted in matters other than matrimonial.
Okay. So what I humbly submit.
We have rejected your plea.
What I humbly submit, latest court date, later enable date, so that the other side will appear.
You should think.
We have said
Serve a copy on the learned counsel appearing in the contempt as well as in the writ petition. That liberty you should have sought for from the court.
Now also we'll give you that liberty. So in addition to taking usual steps, appellant is permitted to serve a copy of the appeal papers on the learned counsel who represented the employee before the learned single judge in the writ petition. Okay.
Can I pray, sir, returnable date? Because
which contempt is posted on which day?
September at least, or August last week.
Oh.
So that the time gap
Take by speed post. Take by speed post.
We are taking by speed post.
Yeah. It is first it is open to the appellant to mention before the contempt court that this appeal is pending and emergent notice is ordered. Okay. This will, under this shadow, you can have some protection. Yes.
I come to them.
The petitioner, my lords, is a junior clerk in the establishment of the District and Sessions Judge Balangin, and he's seeking to assail the orders of the disciplinary committee, of course, the inquiring authority, the disciplinary, and then, of course, subsequent order passed by the appellate committee for the subordinate courts, my lords. The fact is like this, my lords.
What is the disciplinary
my lords?
misconduct? The punishment.
The conduct was that an FIR was lodged against him. He was taken into custody.
For?
Under section 419, 420, 467 and 468 IPC, my lords. He was taken into custody, and within 48 hours of his arrest, he had not communicated, that is the allegation, that he had not communicated to the superior authority. That is the allegation of it. But it has now been proven, of course, by this honorable court in its finding also, that once the district judge, the learned district judge came to visit the sub-jail, he had informed him, and that is also, that has come to light. So that...
it should be communicated in writing.
My lords, communicated in writing to the learned district judge when he had appeared. It is there, my lords, page 43, my lords. The very last page.
Slowly. You appear to be like a PTA, Usha to us. You are running too fast. We cannot, at least I'm not that fast. Yes. So he was arrested on which day?
9/8. He was arrested on 11/8/2021, my lords.
11/8.
My lords.
11/8/21.
My lords.
And he was enlarged on bail?
He was released on bail on 9/9/2021.
When did he inform?
He informed on 13/8/2021. 11th, he was taken into custody. 13th, he informed. 13th of August, my lords.
He was released on 9/9/20.
My lords, he was released on 9/9. But
when he was in jail itself, he had informed.
My lords, they had come for the visit. The learned district judge had gone for a sub-visit to visit the jail premises, my lords.
She was meeting.
My lords?
Appears to be Alice in Wonderland.
No, my lords. The learned district judge generally, all the jails which are there, every once in a month, they go and see the conditions of the
periodic visit where he will smile at him will not be a requirement.
My lords, that I admit, my lords. That I admit.
That's a surprise also. It is kept under wraps. Those visits.
My lords, that I also understand, my lords. That I also get. But then this is the fact, my lords. I cannot deny it.
Your client informed the visiting district judge.
My lords.
That, sir, I am your employee and I have been arrested.
My lords.
That way. But that will not serve the purpose of review.
My lords.
Even if what you say is true,
My lords.
that will not serve the purpose.
I would on lord. But this is the fact, my lord. I cannot go beyond it. So this is where I stand. So after
And the inquiry is only on the ground that you did not inform.
Yes.
Where is that charge?
My lords, that is, my lords will find it at page 26. The final page 21, my lords.
21.
My lords. May I please, my lords?
Yes.
I'll just start from I'm starting from page 20 minutes. On 13/8/2021, last line minutes. The said BLAPL was rejected. On 13/8/2021, a disciplinary proceeding against Pitavasa Mishra was contemplated for committing.
Let us read Rule 20 capital E.
My lords, just placed. I've quoted it at page 6, my lords, para 11. If my lords wants the book, I have the book.
Page 6.
Page 6, paragraph 11, my lords.
The government servant who is arrested.
A government servant who is arrested due to involvement in criminal proceeding or otherwise shall intimate the fact leading to his arrest immediately to his appointing authority to whom he is subordinate.
What is meant by immediately? If he is arrested, how he will be able to communicate to the employer? Immediately after release, perhaps.
No, my lords. That is as soon as he's arrested, he is supposed to communicate. That is
where he will be in the custody of the police.
My lord, that is where the shoe is
immediately appears to be immediately after release, perhaps. If he is arrested, how can he do all that?
They have proceeded on the light, my lords.
How it has been interpreted in any case?
Shall intimate the facts leading to his arrest.
Correct. When suppose he is taken into custody day before yesterday or 10 days ago, how he should inform? He is in the custody.
Taking the custody by the police authority, he has got to inform his authority.
How? My lord's question is very specific. How?
A rule has to be reasoned. We have seen Shreya Singhal versus Union of India. If rule is obnoxious, then it needs to be made noxious. How is it? You can't, law says, any standard, like especially Maxwell on interpretation of statutes. There is one maxim in Broom's maxim. If where law prescribes the impossible, the law presumes that has been done. Anyway, that question is maybe we can put it at a bay now for a moment because he was arrested on 11/8/21.
My lords.
And he was in custody on 9/9/2021. And he informed even during the custody itself.
My lords.
Then that amounts to then very the question of holding disciplinary inquiry, brother.
But there are appeal was there.
No, that's all.
Also there.
No, since he did not get the relief, he has come here. If appeal was allowed, where was the need for sister to come and argue?
Page 40.
Page 40. No, we are asking you by the plain reading of the rule itself. It is very simple. He is in custody. That word immediately has to be interpreted immediately after release. After release, 2 words are missing. Unless those 2 words are read into the rule, rule requires the employee, already he is arrested, under lot of tension. No, arresting authority not under his control. He is under the control of the arresting authority, detaining authority. Then how? This material so that at least after you were released, you inform. During jail visit, which you will wish, that will not be required compliance with the rule requirement. Separately, how to inform? You should have taken a chit. You should have taken small letter like bus ticket size also. saying that I was arrested on 8/11/8/21.
My lords.
Released on 9/9/21. Today is 10th. I am informing you.
That, to my lords,
If you ask a wrong question, perhaps, because the interpretation would be as well from my lord that immediately information may not be Shreya Singhal, it will not withstand Shreya Singhal scrutiny. But did you utterly inform? Is it your stand in the DP that you informed?
Please.
Well, whenever. Apart from that, the decision surprised by this.
Yes, that is there, my lords. Even the learned the appellate committee of this honorable court has also page 43, my lords.
No. Which document? Which government?
How you inform?
How you inform? It's not appellate committee.
Not government also. You have to show the piece of paper now. That you had written that I was arrested, I am released, I am informing you.
Then, my lords, I'll file it by way of affidavit because that paper I have not next.
The problem is that if you did not take that stand, at the third stage now, the start stage now, you have no case.
I understand.
Short case.
There is nothing.
Because fact means that
you will give you time, but you must also realize the consequence of now stating that you never inform.
No, but
No, please appreciate this.
I understand, my lord's query. Please accordingly, my lords. I'll look into it and I'll get back. Because what the fact is that when he had informed the learned district judge, I'll get back, my lords.
Simple. Did he inform? If yes, when and how? Simple questions.
My lords.
That informed, the onus is on you. Because you are saying, let I have informed. They can't prove that you have not informed.
My lords.
It can't be in the negative. The standard.
Let me understand, my lords. Because the fact that I have informed is there in the orders as well. That I have informed within 48 hours.
And actually, they have not said immediately. Neither the disciplinary authority nor the appeal committee that they have not taken exception that you did not inform immediately.
No, my lords, that they have taken.
They have taken exception that you did not inform.
No, my lords, they have said that at page 42 this on.
That issue is nowhere there. I mean, whether your information was immediate or there was delay in information.
They have gone.
If it is a case of no information, then you have to think about it.
They have gone ahead and said, my lords, just for that I should have informed through the superintendent of jail or other authorities or through secretary from the jail itself. That is what is on the ground. That is the ground on which I have been instructed. I'll, my lord, will put it
to show heard in part, not much impressed at this stage. First, counsel is given time to produce cogent material to show that he had informed of his arrest and detention in terms of rule
20A, my lords.
20 capital A of so and so.
Conduct rules.
Call the first week of August.
Congratulations.
Well given.
Sorry, no.
My lords, that is.
Lokadalat order. It is at page 37.
Not Lokadalat order. page 36, 37, my lords. My lords, Loka Adat order. Page 37. First line.
Look at the High Court level.
Yes.
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 My lord.
The learned AGA, Sri Mohanty, on request, accepts notice for the respondents. On the call in the second week of August 2025. Since a short point is involved. Perhaps she has a case, so we'll tell you, not now. Yes.
Obliged, my lords.
But you also take a fair stand. That how it was informed to you.
Criminal proceedings are quashed.
As per the government, while the learned prestigious is in surprise visit,
Correct.
they came to know about thing that is the
So
government.
there only get informed. Otherwise, he would have avoided. He would have avoided.
Informed. So far, the government is concerned. Anyway, I will take in.
Let us see. Let us see. So appears to we can't be that harsh. Yeah.
Item 8, may it be your lordship.
Yes.
My lord, in this case, the simple question which is involved for your lordship kind consideration is that the petitioner before lordship is an existing technical institution, that is a professional institution, private professional institution, which is imparting the BTech course, that is the undergraduate course in engineering, my lord, since 2007, my lord. As per the AICT, that is a central act. Within the central act, AICT is the creature, my lord.
You are appearing for in this matter.
OJ, my primary grievance before lordship is now against the OJ. The OJ, it is a Odisha Joint Entrance Examination Committee. It is the state JEE. As per the special statute 2007, that is the Odisha Professional Educational Institution Admission and Regulation of Fixation of Fees Act. That is a special statute, Miller. It has been confirmed by the Supreme Court because vice of the statute was challenged, Miller. It was 2007 Act, Miller. I have annexed it act along with the relevant
challenge.
Miller. Challenge is that JEE is the creature and JEE is responsible to hold the counseling in respect of admission of all government and non-government college seats. So far, engineering college is concerned, Miller. Here, my college has got extension of approval because AICT gives approval, extending approval from year to year, Miller. Your lordship may kindly come to Annexure 2, Miller, of my brief. Annexure 2 starts from your lordship brief 46, Miller. Your lordship may kindly come to 46, Miller.
Sir, what is your grievance?
Miller, grievance, AICT has extended some seats. That is in the computer science 240. That last year seat was 240 to 300, Miller. That is increase intake.
Intake increase.
Intake
if you
increase.
use the wrong terminology, we will not be able to understand.
Miller, increase intake, Miller. That
increase
is
of intake.
Yes, Miller. AICT has increased intake of my existing course, that is computer science engineering, from 240 to 300 seat, Miller. That is Annexure 2 is clear
60,
to that.
60 is the enhancement.
Then additional course, 2 course in computer science engineering program, it has opened, Miller, AICT. That is in the case of computer science, artificial intelligence and machine. And another is cyber security, 60 seats each, Miller. That is 3, that is 40. Miller?
36 each has been increased.
No, 66 in each of the additional courses.
So 120.
120 and 66 increased intake.
240 it has increased to 300.
300, Miller. Then additional course is 66 each. 2 additional course, 66 each of each course, Miller. 160.
Still, what is your grievance?
Miller, that is my grievance. But AICT,
they should not have increased.
They have increased, Miller, but OJ is not adding in its counseling
That
seat
is
matrix,
not
Miller.
taking note of.
Yes, Miller.
He is not taking cognizance of
that. That is OJ is not taking. Your lordship may kindly.
When this intake announcement was granted?
Yes, Miller. That is under Annexure 2, Miller. Your lordship, it was granted on 29th April 2025. and it was already communicated from the side of the AICT Miller.
April 2025.
Yes, Miller.
So OJ notified the vacancy when? I mean, available.
OJ notified on 19th June of this month. 19th June. Yes, Miller. 19th June.
They have not notified this. Enhanced seat matrix has not been enhanced.
Not been shown. Then I made a representation to the OJ, my last annexure, that is on 24/6. They did not pay any heed towards my representation. Your lordship,
let us see. That is your. We have understood your grievance now.
I want to say.
You want to ask him, na? Yes. Yes, sir. Why the AICT is the competent authority?
In the matter, the lordship may kindly refer to his own averment, my learned friend's own averment.
Yeah.
In page 15, paragraph 17. Page 15, paragraph 17. This is what he has stated. But, and this is precisely the issue. But the petitioner understood that Orissa JA, without instructions of OP number 1, that is SDT department, cannot include the aforesaid increase in new improved intakes of the petition institute in its ongoing counseling process, which is absolutely illegal. Now, we are hamstrung by the fact that we are under the Skill Development and Technical Education Department of the state of Orissa. That is one aspect of the matter, which the instructions have to come from the government under whose aegis we function, and the brochure and everything is printed under their instructions. That's one. Secondly, my lord, they have to obtain an approval from the BPUD, which is the affiliating university. Affiliating university.
Even after intake.
Unless the course is affiliated, you get an approval from the AICT, that is fine.
That's only for intake.
Yes, they've got. But
thereafter, there is a whole lot of.
Yes. There are a lot of other paraphernalia, inspection and other things would be there. So the BPUD has to do all those part and say, all right, we agree with this situation. Of course, my learned friend has maybe a couple of judgments in his favor. One that is citing that Jai Gokul, and probably one division bench judgment of this court. Probably, Manat, I don't.
Jai Gokul is Supreme Court.
Jai Gokul is Supreme Court. Division bench probably.
No, the facts in Jai Gokul.
Maybe. But they are saying that once a central act gives an approval, the
Jai Gokul does not, rule out the approval of the university.
No, affiliation, that inspection.
So the latter it has.
Jai Gokul doesn't really rule out the inspection that is to be conducted for the affiliation. So that.
No, when they grant intake or enhance the intake, what is the procedure? Whether that procedure and the procedure for grant of affiliation, are they identical? Otherwise, it will be duplication.
There is a slight difference in both. There is a slight difference in both because on field and on the ground, the inspection has to be done by the affiliating university. Whether they
we have understood now. Is it your case?
No, I have no, but right now I am just, he just gave.
Then you take the notice.
You have to take notice. BPUD has to appear and give the reactions before your lordship.
Who?
Technical university.
Who appears in this case?
Notice to go.
And for the department also has to file.
Miller, just may I be allowed, Miller, what is my anxiety?
We have understood now. We will have this matter next week, Miller, because only timeline, at least they should be given meeting time.
If your lordship will please to pick up the next week,
that's fine.
23rd minute.
Very well.
20.
Miller, last date for counseling is that is the
which date?
That is the 20. I have already annexed. That is
we are asking you the date.
Miller, 19th July is the last date for counseling. Your lordship may kindly fix up the any date before the last. That is the locking period. Last date for locking period.
The difficulty is that on 29/4 you did not approach.
Miller?
On 19/6 you did not approach the court.
Miller, my problem started. Miller, whatever my learned senior advocate is submitting, Miller, that is not factually 100% correct.
Kindly appreciate, sir. You are
Miller,
that time has not come for you. Let them take instruction.
Affiliation is not required for J Council.
Kindly listen the order, sir.
Issue emergent notice Learned EGA Mr. Mohanty on request accepts notice for
1 minute.
OP number 1. Learned counsel on record, Shri.
I will appear for the opposite party number 5 AICT.
You are senior advocate.
I'm senior.
But we cannot issue notice to you.
Mr. Amitabh.
If you say somebody, we will. The senior advocate is not supposed to act.
No.
She can only argue. That's all.
Sritam Mahanti. Mr. S. Mahanti.
Yes, Mahanti.
That panel counsel accepts notice for response number
2, sir.
213. 213.
No. 3 is Mahanti. Another Mahanti rather.
I'm only for
Policy planning, what is 3?
No.
DT.
I'm only for 2.
Kindly exchange your give pleadings. Your pleadings to the
In course of the day, my lord.
petitioner to serve copies of the papers before sunset of the day on the learned advocates appearing for the other side. First, for this matter.
Notice to appear for by speed post.
By special messenger, my lord.
Can you just listen? Speed post with AD. It is at Raurkela.
Yeah, Rahul.
Take speed post in 48 hours. Speed post with AD returnable on today's 19. Today's 10. You are saying 23rd.
19 million.
Returnable on 18. Returnable on 18. Or we can make it 21st.
But by that time, 19 will be the last date.
19 July.
19 July, that is the schedule as per their
So not
schedule.
23rd.
No, my lord.
In instances, Manoj, just to assist your lordship.
Beyond time also, admissions.
No, by your lordship's order,
several cases.
We can do that.
It can be extended.
Always extended by a week.
On the other
My
hand,
learned friend has been also.
maybe, but we let him not put to that risk.
No.
Let us see for this matter.
And you give your appearance in a piece of paper for OP5, please serve copy.
Miller, I have already served a prior copy on my Lord and Senior Counsel Miller and also AIT. In addition to that, I am ready to serve the extra copies, Miller.
18.
Your Lordship has been pleased.
So returnable on 16.
16. 18, your Lordship has been pleased to pick up.
India Post.
So, sir,
Postal tracking report of India Post will be more record.
Yes, Mohanty.
The person who is in the panel and regularly appearing for BPUD, they can also intimate by that. It is easier for them to make it convenient.
Tushar Satpathy.
Yes, Satpathy normally. It will be easier.
if your Lordship will please to mention his name, then my learned friend can accept the notice.
Of the urgency of the matter as pleaded by the learned counsel for the petitioner. In addition to the taking of notice, he shall serve a copy on learned panel counsel. He usually appears for BPUT during course of the day.
Yes, Miller. Miller, IA is also there. Your Lordship may kindly please to issue notice in IA. Interim prayer is also there, Miller.
On main matter.
Yes, your Lordship may pick up for orders, Miller, only. My prayer is orders on that day.
Fresh admission.
Fresh admission.
Listed in the same condition.
Okay.
Item 9.
I do oblige you, Lordship.
Yeah,
Launched 217 days delay, my lord.
17 days. You had assured us that you will show an appeal which is filed without delay.
That I have not read. 217 minutes, 217.
On merits, what is the matter?
Not so.
Not that good.
Not that good. But I'm not, and myself was also not feeling very good on the merit. Only my prayer would be that if I may modify the prayer, the interest portion your lordship may expunge and other part that was a recovery from the pensionary benefit of the employee. 1,19,000. That honorable court has struck down, and that order was struck down. And a refund with interest of 6%. That only we are concerned.
Where pension is recovered contrary to law. Yes. Then Apex Court said, take Padmanabhan Nair versus
Yes, that
83 Supreme
Court. I'm conscious of because
you have to. Government cannot retain money of the citizen.
Yes. If it is a deliberate default.
Mr. Ponda,
No, it's not on intake.
Ponda, it is 6% per annum.
No, serious.
So Lordship is directing 10% per month.
No. Lordship, kindly say in failure of refund, it would have been the penalty.
No, how long that money remain with
only
you?
difference is that if you did not deduct it, suppose you would not have deducted and kept that money with you, then that would be the only saving part of it.
No, how can state retain money of the citizen? We are asking you now.
No, we have not retained.
You have deducted.
Deducted that there was a due.
That is found to be wrong now. That is ordered to be released.
Without
what do you say, brother? How long your money was with you?
My lord,
How long
from 2011 to till date.
11 to
2011, that was recovered and kept with him.
You don't want to say the year.
2011, man.
2011.
11, man. They have recovered from me.
Zero, sir, because if it is paid in zero, Lordship is asking till which year it remained unpaid.
How long the money remained with the government, your money?
From 2011 to till today, my lord.
2011 to
Till today, yes. It is with him. They have recovered from the pension and benefits of the petitioner's husband.
You have kept it.
No. Lordship, kindly peruse paragraph 9. Paragraph 9. In the instant case, admittedly, the deceased government servant was allowed to receive.
Page number?
Page number 68.
68.
Running page 68.
Go to 68.
And the internal credit page 4.
The instant case, admittedly, the DCA government servant was allowed to receive a evaluation in the If 5 years are reduced, 5 years if we reduce, then it will be 2011 to 2025, minus 5 years. We can reduce 5 years because of the last sentence in para 9. Brother, what will you do? If we admit it and stay it, you will not get that also.
Yes, sir.
Therefore, if you agree that we can say that no interest is payable for a period of 5 years. That is 2011 to 2016. So the interest would accrue with effect from 2016
till today. Yes,
till date.
Yes.
And it's not a deduction, it's actually payment of pay matrix. So it's not deliberate. I mean, it's not a kind of a fine or a interest or something like house rent. So a pay matrix was fixed and it was paid. So that they said it, but I mean, it's a policy that they said that it's not payable. It's not payable. I hope so. That way you agree for this.
Yes, I agree with you.
The order passed by the Cadet Single Judge dated so and so. It is 30/11/2022. Passed in WPC issue bracket OAC 865 of 2012. In the said writ petition, the widow of the deceased employee, Sri Prafulla Kumar Behera,
Felicitated,
who passed away on so and so date, on dated dash. Challenge the order of recovery of an amount of rupees 1,19,695 that was recovered from the death dash com dash retirement gratuity of the late husband of the petitioner. And the balance amount was sanctioned in favor of the petitioner by office order dated 28/7/2011. The enhanced amount that was paid, just add one line, it is not disputed at the bar that the enhanced amount that was paid to the petitioner was pursuant to pay fixation with effect from 1/5/1989 The date of death is 22/10/2006. That as we know. The prayer made in the writ petition was to refund the deduction of rupees 1,19,695 that was paid as back wages. No, not back wages, as differential salary after refixation with effect from 1/5/1989. The learned single bench, relying on the decision of the Supreme Court in State of Punjab versus Rafiq Masih, into bracket 2015, bracket closed, 4 SCC 334, held that such recovery was not supported by any reason, and the amount shall be refunded to the deceased employee's wife with interest 6% per annum. It was further held that the employee was not in any way responsible for the amount being paid to him, as the state government on its own refixed the salary and paid the amount. This is for fresh admission, Mr. Pandit. For orders. Notice has been issued.
Delay has to be condoned.
The matter is listed today for condonation of delay in filing the condonation of reported delay of 217 days in filing the writ appeal, and listed for orders. Noted counsel, Mr. P.C. Acharya, who was appearing for the petitioner, has already appeared.
Yes, ma'am.
Or has instructions to appear?
Yeah, appeared.
Already appeared. On consent of the parties, the matter is heard and finally disposed of. We are not inclined to interfere with the order passed by the learned single judge, which is just and proper. However, considering the fact that the deduction was made after payment of the differential area salary as a policy matter of the government, we feel it appropriate to reduce the payment of interest for a period of for the period from 2011 to 2025 at 6% per annum, as directed by the learned single judge.
2016.
5 years.
Reduction from 2011 to 2016.
Okay.
The remaining period from 2016 till date of payment the interest shall be payable at 6% per annum.
Because of Rafiq Masih.
Because of Rafiq Masih.
The time may be fixed.
Yes, Mr. Panda.
Within what
compliance, also compliance report as my lord directs.
8 weeks. 8 weeks.
The payment shall be made within 8 weeks and compliance report shall be filed before the registry and placed on record.
If he does not pay within 8 weeks, this order remains.
If the payment is not made in 8 weeks, the order passed by the learned single judge dated so and so in so and so shall automatically revive, and the entire period shall bear at interest of 6%. 8% per annum.
If you would comply, that question will not arise. Yes.
Item 10.
The judgment has been impugned was also challenged by the state in a writ appeal bearing 1456 of 2023. That was dismissed on delay and latches. Because of a delay of 250 days, some up to 250 days. That was subject matter before the Honorable Supreme
Demanded.
So this
is give the memo for it as to the learned counsel for the appellant submits that similar challenge, identical challenge to the order impugned in the present writ appeal. The writ appeal number
1456 of 23.
1456 of 2023.
By the state.
List along with, yes, Mr. Ponda, 1456 will be listed.
Yes, sir.
1456 of 20, list along with 1456 of 2023. Well,
next week.
1456, 1445 by 2020.
No, please check with Mr. Rautre and give it. So that will, because we do not know.
1456.
তাহলে দেখেই দেন just for which states next week
How many of such matters are there?
and how many of such matters?
How many matters?
No, one by the state, one by the president.
Not in these two. Many other matters were there.
500 in one batch.
Yes, all matters. Yes, all
So
matters.
kindly check
Fix
wherever you are the appellant, please check how many are demanded. Because we cannot know, it's very difficult.
Correct.
Date what is it? Next week. 18th of July 2025.
In this appeal lord, they were not the party.
Whatever, sir, they will seek leave. But
They have
he's
not
saying,
filed in
whatever, they will do that. That's not
Oh. Item 11.
Yes, my lord. Appellant is the husband and the
Direction is given to consider the case of the petitioner in accordance with the rule which was prevailing at that time, 1990 rule. But in the meantime, that rule has gone an amendment, and your lordship has delivered also to
Covered by this.
yes, covered by the
judgment you please give.
that rule.
Upon by Rachid, you have a copy of the judgment.
Yes, yes. Nice.
Look at.
The subject matter of this appeal is substantially similar to the one we treated in the writ appeal number.
You want to take a speed board answer.
So it's we disposed of on. No. First, the operative portion of the appeal.
These are writ petitions.
Petitions.
But you are.
This is writ appeal.
This is writ appeal,
But that is identically similar.
identically similar.
Or it's a mistake. The WPC is a mistake or it is correct?
Okay, let
WPC. No. Yes,
No, it may be our mistake.
WPC, your lordship have passed that order, but that is applicable to his case. Because we have been directed to consider his case in the light of the
Amended rules how to this one.
Your lordship, I have got that rule, that amending rule. Your lordship.
Of
Yes, Lord.
22 between Minati Sahoo versus Adjournment, disposed of by us on 23/6/2025. First, the operative portion of the order. I did understand. Say please. Yes.
Item 13.
also a state appeal involved in delay.
Delay is how many?
134 days.
134 days. 130. We'll condone it. 134 days.
134 days.
Application accompanied by affidavit seeks condonation of delay of 134 days grouped in filing the appeal. 33 days. 33. First, delay is not that long, and appellant happens to be the state functionary. First, some plausible explanation is offered for the delay. First, no prejudice should be caused to the other side just by condoning delay, in as much as matter would be heard on merits. First, next, in the above circumstances, application is allowed, delay is condoned. What is the on merits?
It is the regulation of the employee. She has already served 30.
32 years.
32 years.
32 years.
Yes.
32 Which judgment we held? The regulation is considered.
Already passed 2 to 3 judgments.
No,
Lordship's judgment.
What the learned single judge said?
Not a single judge.
I mean, selection process and all these things, advertisement is there.
That was there.
So that judgment of sales tax tribunal or something to a department, commissioner of sales tax, that judgment.
Whether 2008 resolution applies?
No, there was a government resolution in earlier 1993 that before a cut-off date, those who are appointed, they can be regularized. And after that cut-off date,
they are not.
But in fact, in this case, there is a typical thing has happened. She was earlier engaged and disengaged. Thereafter re-engaged. So re-engaged is after cut-off date.
What is the gap between these two?
Disengagement. 8 months.
8 months.
8 months, but no notice was issued. Nothing has been communicated due to paucity of funds. They have taken a decision and kept it inside their file.
Your case is that earlier engagement prior to 12/4/93 is not denied by them. Or it is denied?
No, not denied.
Is simple dismissal or what?
Well,
you want it to be argued or to be dismissed?
3 decades, 20, how many years?
32 years. He is still serving.
Direction is for regularization.
Regularization.
Citing Uma Devi and ML Kesari.
ML Kesari goes in his favor.
Yes.
ML Kesari makes an exception to Uma Devi. Para 53.
Yes.
Is it not?
Yes.
The single judge has cited that judgment.
Those two judgments have been relied upon and other.
State is in appeal to calling in question a learned single judge's order dated, whereby, please be seated, sir, whereby appellant, respondent employees WP number so and so having been favored, a direction has been issued for regularization of her services. First, next. Learned EGA, Mr. Panda, passionately submits that the order of the learned single judge is liable to be voided since it runs counter to the ratio in the state of Karnataka versus Uma Devi, there being no matchable fact matrix to ML case. First one, he adds that the ratio of these two decisions having been wrongly construed, learned judge, single judge has erred. Please be seated. Yeah, and therefore interference of this court is warranted. Learned senior advocate appearing for the respondent employee at once points out that the case of the employee is not one of backdoor entry, semicolon. There was a selection at some level pursuant to policy of the state as it then existed, obtained. 7. The employee has put in about a little less than 3 decades of long service with no blemish in service records. First, he also adds that the learned single judge has rightly granted relief by placing reliance on both the decisions aforesaid, and therefore interference is not warranted. Of this court is not warranted. Next one. Having heard the learned counsel for the parties and having perused the appeal papers, we decline indulgence in the matter, broadly agreeing with the reasoning of the learned single judge on which he has structured his improved order. First, here is a case where the employee gained entry to the service after some level of selection process is not much in dispute. Sir, employee has put in 29 years of spotless service. Sir, even if there was some alleged break in service, the same is not that long. And that would not loosen the case of employee for regularization. First, we are, despite vehement submissions from the side of learned AGA, we are not much impressed that the learned single judge have erred in applying the ratio of ML Kesari as an exception to the general ratio in Umadevi. First. Next, in the circumstances, appeal being devoid of merits is liable to be accordingly dismissed. Within what period you are doing that regularization? Learned single judge has fixed any period?
1 month.
1 month.
1 month.
We'll give them 2 months.
2 months.
8 weeks.
Okay.
The order of the learned single judge shall be implemented within an outer limit of 8 weeks. 8 weeks. 8 weeks.
But your lordship may observe that earlier period before the breakage, that cannot be counted towards the.
Wait, no. Yeah, that is in fact, if you read Dharwad Daily Wages, of course it is overruled is another thing. But see the policy, the underlying policy of that judgment is after we introduced socialistic, we introduced secular socialist 2 words to the Indian Constitution. Once it is socialistic, then gradually we lurch in favor of the employees. It is not that we are enacting Karl Marx Das Kapital, but since it is socialistic, we have to take note of little leaning in favor of employee force.
State of Odisha has been policy in 15597.
Even on that extent.
So that 15597 policy is Umadevi kind of policy. Maybe the Justice Balasubramaniam, after seeing that in Odisha, was influenced to pronounce that in Supreme Court. That cut-off date of 12/4/93, 15597, regularizing their services. If you dispute those things before the single judge, then you have a case.
30 years.
And he says that it was paucity of funds.
32 years.
32 years.
More than
32 years. Since less than 3 months, 3 decades, not little less than. Make it more than 3.
More than, because 93 itself is 30.
That's what. Yes. If you send that, where is she should go? Yes.
Item 14.
My Lord, I am at 12 for
This matter will also directed last occasion to both the parties to file a date chat along with written note of submission. And I have received a date chat note of submission from the Learned Counsel for the petitioner, and I am filing my date of yours today and seeking one adjournment
On this matter, in the second week of August 2025, at the request of the AG.
I am filing this
what date that you date chart filed by the learned AGA, accepted all the comments.
and soft copy on all. I have also soft copy on.
Just look at the VC also. This doesn't allow them. Someone waiting in this VC. Now they're coming only after waiting in the waiting room.
Item 28.
Item 26.
26 you are.
26 taken up after vacation.
Huh?
After lunch, my lord.
After vacation.
After lunch, sorry, my lord. After lunch. After lunch, my lord.
After break.
Password.
But where is your other side? Why you are adjourning it?
Again, code number 2.
So you are there.
No, actually, my senior is.
So he is
Password. Yeah.
Item 28. Item 28.
No. Second person. Okay.
Item 29.
Lordship, item 29, I need to file counter, so a week time to be given.
Writ appeal.
It's a rate appeal.
Lordship, I am for the appellant.
29 is appeal.
Yes,
Yes,
sir.
Your Lordship.
Where is the question of counter?
My senior said to file the counter. We have already prepared the counter.
No, how can you find the counter in appeal? Have you filed the objections in the court before the court below?
Yes. Yes, Your Lordship.
Say
In
some
the
other ground.
rate petition, we have filed the counter objection.
Then you cannot file appeal, objection to appeal. This is continuation of the original same proceeding. Is it not?
Yes, ma'am.
Not different proceeding,
No.
same proceeding. So you want file?
Yes, ma'am.
Yeah, some say some other ground.
Your Lordship, under the appellant, Your Lordship, matter was listed on my mention. Your Lordship, a short date may be fixed.
Last week, July, last year, this month.
Bless you.
The request. Yeah.
I am for the respondent number 1 in WA 190.
This is a matter which has a large number of cases have been disposed of. In terms of the judgment, you will also get the third item. The state is the appellant. State versus Hemant Kumar, writ appeal number 197 of 2024. An order has been passed on 3/3/2025.
You can sit down. It appears you came running here.
Yes, I am. No, I am now.
Here, Malad in 30, Malad sir, directed when my learned senior is submitting WN number 197 of 2024. It is the sub item number 3, ma'am.
Correct. State of Orissa, Hemant Kumar.
Look to that order.
Disposed by Honorable Single Judge. It is a series of matters are there.
Supreme Court remanded.
Exactly.
Same story.
So, Malad, some of the cases, it has not been regularly so far the notice is concerned, other side had entered appearance, not appear. And some of the cases, they have interveners are there, whose name is not being reflected.
Maybe.
From that, may submit. A date be fixed. Then Advocate General is to address on these issues.
AG wants to come here, I assume.
Well, later on, because some other day. But the entire background, you also look where your Lordship have passed an order on 3/3/2025, where my Justice Sahoo was also a member of that bench. I'm just reading the crux of the matter is this.
197.
WA 197 of 2024, order number 7.
List को जिवे list 187 click करो. The batch of cases.
197.
Writ appeal 197.
Just stop there. Click that box. Very model apple.
Give a copy. Got it.
Me copy that. We are having all.
We are having this. But also look to paragraph 4. The appeal has been moved on behalf of the respondent. Reliance is placed in view of the view taken by the Lord Single Judge of this court on the judgment dated so and so
in WPC number so-and-so, reported in so-and-so. This judgment, of course, was challenged before the Supreme Court and the state, yes, that judgment has been implemented by the state. The same issue. The issue is, yes, this issue is a rule which has been, there are 81 rules, whether that can be extended for pension in respect of the employee of block grant schools, aided schools, that is block grant schools. That is the entire issue. Yes, that is aided. The quotation is this. The plain language of Rule 3 makes it clear that irrespective of the nature of the grant in it, given by the government to various staff of a college, once the college has required status of one coming under the direct payment system, then even if a staff is not getting full salary from the government under the direct payment system or getting only some rate in whatsoever form, including block grant, he will be covered under the rules and be entitled to pensionary benefit under the rules, taking into account the amount of and the amount of the aid, the aid he receives from the government as salary and the period of his qualified service. Para 5. Appellant will be heard on what is recognized non-government college or high school or senior basic school or ME school. All are covered by this rule, which comes under the direct payment system. The rule describing the institutions as non-government itself implies something is received from the government. We would like to know whether the distinction is of the grant received by the institution or directly by the employees. If the employee receive it, it must mean direct payment. That is what your also passed on.
So what they say, because of, I think, one judgment of Procedural, whether an institution is a granting aid institution or not. That granting aid may be for the institution in a wholesale way, for a department of the institution in a sectarian way, for employees of the institution or for a section of the employees of the institution.
Right, sir. Right, Your Lordship is absolutely right. That is what that is what we are trying to impress Your Lordships. Even a block grant is a grant, but it comes to the
how rule is.
Rule is. That is there, 81 rules. If you can see that the entire crux of matters. That rule is Orissa education Yes, Orissa aided educational institution employees.
Sir, can you get the page?
Yes, same book, yes. 880. Okay. Answers. Can you also look to Rule 3?
But in the absence of the groom, only with the bride we cannot perform the marriage.
That is exactly that we cannot also. We cannot, because the adversary is coming. We very much. Kindly look to C. Employees means an employee of an educational institution of the category specified in Rule 3. Now let us also kindly come to Rule 3. Yes. Application of the rules. These rules shall apply to the teaching, non-teaching staff of all recognized non-government colleges, high schools, senior basic schools, and ME schools, which come under the direct payment system, and all non-government primary schools, including Sanskritul and junior basic schools, fully aided by the government Education and Youth Service Department directly or through Panchayat Samiti constituted under the Odisha Panchayat Samiti Act or through a notified area council or municipal constituents also, provided the government may by general or special order as may be issued in that behalf specify and other educational institution or category of institution and the staff.
And what is that and?
Specific any.
Yes.
Other education.
Any other education. So now we are emphasizing the first part, Rule 3, first part. These rules shall apply. Yes. Which come under the direct payment system.
Yes. What you say.
Yes, sir.
The expression fully aided by government in there, na?
No, sir.
So that's not implies concern.
You also kind of come to first parts.
There are two parts.
Yes, but
you also is under the direct payment system.
To understand.
Yes.
May I read it again? Mr. Swatike, may I read it again? These rules.
English is the most mischievous language, said George Bernard Shaw.
So there is a disjunctive clause. That and is there.
And is disjunctive or conjunctive is the question.
Yes. Absolutely correct.
And is disjunctive.
Yes.
Means two classes.
We are covered with first class.
If you also look to the judgment of the single judge, it has been interpreted and clarified as disjunctive, not conjunctive.
No, therefore, is it there enough?
Disjunctive. That's right. So the whole question for consideration of the lordship is now, if I'm correct, if a judgment has been passed maybe by a single judge, but then whatever, maybe on the ground of limitation, it has been dismissed. That judgment has been implemented in case of one or some employees. Can it be now, so far the other employees are concerned, can it be interpreted in different manner?
You cannot create a class.
Right.
That is our very simple.
So we leave it to Lordship also here, the Learned Advocate General. And the Learned Advocate General was kind enough for last time while the matter was heard. They said that we are trying also to sort out the matters. That is what he said. Then that is for my not to hear them, and your Lordship will decide.
But that very rules applies to aided educational institutions. Your Lordship may kindly see the definition. Rule 2D. 2D. Small d.
Institution means.
Institution means an educational institution as defined in clause B. It is wrongly, not B.
B, that is B.
B of section 3 of the Act.
It needs to be read B.
Yes, but that is wrongly printing mistake.
Indian education institution has been defined under B.
Clause B of section 3 of the Act. Section 3B of the Orissa Education Act defines an aided educational institution. You will also may kindly see section 3B.
That is the substantive act.
Yes.
Page at
That's at 107.
Yes.
My lord, may kindly come to page 115. 115. Section 3B. This was incorporated by way of an amendment. Aided educational institution. Aided educational institution means private educational institution which is eligible to and is receiving grant aid from the state government, and includes an educational institution which has been notified by the state government to receive grant aid. So there are two sets of institutions, aided institutions. One which is receiving grant aid from the state government and also includes an educational institution which has been notified by the state government to receive grant aid. All these institutions have been notified to receive grant aid from the state government, because the concept of block grant, for the first time it was introduced in the year 1994 by way of an amendment made in the Orissa Education Act, that is by way of incorporation of section 7C. You also may kindly say section 7C.
One second. Kindly come to 3B again.
Yes. Aided educational institution means private educational institution which is eligible to.
Right.
Yes.
There is comma.
There is comma.
Then and B.
And is receiving grant aid from the state government. This is first part.
Why comma?
But comma is there. The second comma is there.
Comma and then comes and.
And
so we do not understand.
But there are two commas.
That's
so
all.
far as the first part is concerned.
First, the printer has put his comma.
No, there are two commas. There are two commas.
But generally, after comma, and does not come. General.
Yes. Absolutely correct. Absolutely correct. Absolutely correct.
What my lord is asking that if are there two conditions eligible to and receiving?
Eligible to receive grant aid. Eligible to receive grant aid.
Suppose receiving.
And is receiving.
We don't understand. Unless he is eligible, where is the question?
Yes.
That is the wisdom of the legislature.
Therefore, we are asking you.
Yes.
If it is eligible also.
Eligible to receive grant aid. That is the first part. And is receiving grant aid from the state government.
Is it first class or first part?
My lord,
Are you using the word part or class of the institution?
my lord, there are two conditions so far as the first part is concerned.
One class. It cannot be.
Yes.
Unless institution is eligible.
Eligible.
It is the question of grant.
Yes. That is a precondition.
Only
Yes.
after it is found to be eligible.
Yes, yes.
So eligibility is a sine qua non.
Sign for not getting granted. Yes, absolutely correct. But we are concerned. Yes.
We can't read
In isolation.
by provisions of statute in an odious man.
Yes, odious man.
Is it not?
Yes, yes, absolutely correct.
If my interpretation is placed,
Yes,
then that part becomes odious.
yes,
Therefore, if we want to avoid odious,
yes.
then some meaning has to be assigned to it. To me,
If eligibility part.
in other words,
Yes,
no, you can't amputate also.
Yes.
You can't do amputation.
yes, yes,
You have to read it because the legislature in freedom has put, it's not some rules.
yes.
Is it not made by some administrative authority?
This is an act.
Enactment. The presumption is the legislature understands English
Yes,
and it has not used any surplus words in the script.
yes.
Therefore, I'm just thinking,
There must be object
objective
behind it.
whether sometimes legislature also duplicates and
Yes, yes.
there makes grammatical errors.
Yes.
We have found number of. It appears that way. Otherwise,
Yes,
though whether grant is made or not, all those who have been granted one class,
yes,
all those who are not being granted but who are otherwise eligible for grant will be another class.
yes.
Apart from the others who have given receiving. How we should read it is our question.
parenthetical sentence টা কোন জায়গা grammatical কই দউছ grammar
Some institutions.
Notified option. Regardless of these two. Notified
My understanding would be there are some institutions which are eligible, but they are not receiving grantinate from the state government. They are eligible, but still then they are not getting grantinate from the state government. Therefore, in the first part of the section 3,
such institutions would come in.
yes. And so far as the second part is concerned, we are concerned with the second part and includes an educational institution
Which is notified.
which has been notified by the state government to receive grantinate. We are coming under the second category.
You are notified.
Notified.
Yes.
Under section 3B of the Orissa Education Act.
Where is that notification?
Notification file.
May I be permitted for your lordship for a moment?
So it is the inclusion category.
Inclusion category.
In other words, definition is
Yes.
means and includes definition.
Yes.
So liberally construed.
Yes.
May I be permitted for a moment? Sir, we are at the point.
second.
These are
One second. Means definition, includes definition,
Yes.
means and includes definition.
Yes.
These are the three categories of definitions
Yes.
which standard books on interpretation of statutes
Yes.
see. If it is just includes definition, that is very wide.
Yes.
Field is very wide. Maidani,
Yes.
it's very wide.
And so far as the second part is concerned,
I have
why
not
it was
completed.
included?
I have not
Can you
completed.
listen? Can you listen?
I have not completed.
Yes.
If it is means only if the legislature says A and B.
Yes.
You cannot add C. All right?
Yes.
You agree with this? If it is means and includes,
Yes.
then focus is shifted to the word includes. This is what GP Singh refers to apex court decisions.
Yes.
Only those who have been included within the category alone will be entitled to
Yes.
special
Yes.
treatment.
Absolutely good.
With this approach, you can proceed that matter.
Yes.
Sir,
For that, the AG has-
your approach is absolutely correct. There is no doubt over this. But the question for consideration in all these cases are, admittedly, all these institutions or the employees, they are getting the grant either by a block, that is a block grant. With that, they have been notified under section 3B. There is no dispute over this, sir. Now the
In
whole
other words, what you say is,
yes,
regardless of nature of the grant,
right, sir. Yes, right.
central point of the section
Yes, sir.
is
Yes.
grant
Right.
and not its nature.
Right, yes, right, sir. That is the entire case.
That's how the single judges structured the question also.
Because the concept of block grant, why this was amended in 1990. Because the second part of section 3B is concerned, it was amended in 1994.
You said that.
Yes, but your Lordship may kindly see that. My Lord, it was amended in 1994, that notification part.
No, but exercise in the absence of Advocate General, if we do that exercise, you still come.
Yes, that is exactly.
We have to do it again.
Just to in fact, you can put forth there. They say that block grant is not a grant.
Yes.
Yes, yes.
That is exactly what my Lord Justice Sahoo said. That is, I think, that is that
exactly for pension because
that is
not a grant.
I think Justice Sahoo has right. He said that
Grant is not defined. Grant is not defined.
No, grantinate, no, it has not been defined.
Grant is not defined.
As Mr. Swai said, that has undergone a change right from 1994 onwards. That is what.
That was incorporated by way of an amendment in 1994, section 7C. The
question is that Asif queries that can we not get assistance from the statute regarding definition?
Yes.
That grant or grantinate has been
Grantinate, for the first time it was incorporated by Act 13 of 1994 in 1994 Grantinate Order, which is statutory in nature.
So, but Education Act doesn't define.
Education Act itself, 7C4.
7C.
Defines the grant.
Yes. So come to 7.
Grantinate. Yes. Grant means grantinate only.
Yes. So straight we come to page 137.
Section 7C.
137. Grantinate. The state government shall, within the limit of its economic capacity, set apart a sum of money annually for being given as a grantinate to private educational institutions.
It enacts an obligation on the state subject to economic capacity to give grant. That's all. It does not say what is meant by
Yes.
Therefore, common sense will be used.
Yes.
Common parlance.
If there is no yes. So you also keep it to Mr. Advocate will argue then.
No, you have argued.
Right. So this is the entire background. We have not.
No, we understood.
Right.
That's good.
And all grantinate orders that came into force after incorporation of section 7C. Because under section 7C4, the concept of grantinate order that was brought out. You Lordship may kindly see section 7C4. Notwithstanding anything contained in any law, rule, executive order, or any judgment, decree or order of any court, no grantinate shall be paid and no payment towards salary cost or any other expense shall be made to any private educational institution for any post or to any person employed in any such institution after the commencement of the Orissa Education Amendment Act 94, except in accordance with an order or rule made under this act. Grantinate fare admissible under the said rule or order as the case may be shall be payable from such date as may be specified in that rule or order or from such date as may be determined by the state government. So thereafter, in exercise of power under section 7C4, different grantinate orders were framed.
We'll argue, Mr. Swai. We try and also keep it to next week so that yes.
Which date?
Week after it. Another writ appeal number 651 of 2024 and writ appeal number 530 of 2004 against the very same judgment the state has filed. That may be listed.
Caller.
I'm giving.
Caller. 623.
Whatever sir, kindly give it.
Give them that so that in that
kind permission.
Very soon.
197. So 197.
Yeah.
Where we have already
In the week commencing 21st, you are saying? Week after, Mr. Manti?
Yes.
Which date you suggest? 21 to 25?
No.
24th.
24th, all right. That day again, you should not seek adjournment because again it will be.
If time will be fixed, it will be better. Yes, sir.
In lunch, may after lunch.
We agree. That day you inform you. That day we will have this matter in the afternoon.
At 2 p.m.
Yes.
You talk to the AG and come back. Yes. Then
You inform your learned colleagues.
also.
Any date from 23rd to 25, you note it down.
Well, call it that.
Let's do it.
I am oriented with my
posted today for the file their opposite party.
I received
File their counter affidavit.
It's a promotion regarding junior assistant and senior assistant in the Hon'Ble High Court of Orissa.
How much for that time you require, sir?
3 weeks time.
But it's peremptory order. We are not passing any order.
I'll
How can you pass an order after peremptory order? As collected by the learned counsel for the opposite party, list on.
It's August.
30th.
30.
4th of August.
4th of August. The learned counsel for the petitioner brings to the notice of the court the order dated 18/6/2025.
Yes.
Item 38.
My lord, I am for the petitioner, my lord. This matter regarding this issuance of priority 2 certificate for admission into MBBS course under ex-serviceman category because the petitioner's father is a war-injured person and he is getting war-injury pension. The opposite party has not, they have not filed the counter.
Policy has been changed. Lord Senior was appearing, that policy has been changed. They have made it only for serving.
No, madam. So far as my knowledge is concerned, there is no such changes.
Yeah, I don't say that I know because I no more can know and
yes,
knowledge. But have you examined that? That's what
yes, they have not filed a counter affidavit because there are government of India is there also, state government as well as the Jilla Sanik board as there.
Union is appearing.
Yes, madam.
Yes, we are appearing for the number.
Appearing in last occasion, he has also taken copy.
Yeah, how much time you will take for appearance? Admission will look at this month.
When admission? Last date for admission?
Last date.
That instruction I didn't have.
All these army personnel, why have made Mahar Regiment a party? 56.
Because they have issued the war injury certificate.
War injury certificate?
Yes, my lord. And pursuant to that, he is getting war injury pension.
Appearing for all. Rajya Sanik, Secretary Jilla Sanik.
Actually, Secretary State Sanik Board has might have filed the counter because he has over phone he has talked to me. He might have filed the counter, but as regard to our counter is that.
If you have heard your learned colleague, he says that counter has not been filed, and we also do not have any counter on record.
We have not filed. We have not filed. We have to supposed to be filed, my lord.
Then who are the appearing parties? Notices have been issued.
We will be appear on OP number 2, 3, 4, and 5.
5 and 6.
And 5 and 6, 5 and 6, there is a separate appearance of other councils.
5 and 6.
He has taken, my senior friend has taken. He has taken this 5 and 6 because I was objecting.
Anyway, now he says he cannot appear.
2,
3, 4 he appears.
Yes, ma'am.
5 and 6.
He has also accepted notice on behalf of 5 and 6.
He takes notice, but
he cannot. Yes, obliged.
The learned counsel for the petitioner submits that you write your appearances in a piece of paper. Mr. Pradhan for the petitioner, Mr. Devraj Mahanti, AGA for OP 1, 2, 3, 4, 5, 2, 3, 4, Mr. DSJ along with Mr. Sudipta Panda. CGC. It is submitted by the learned counsel for the petitioner that he was under the impression that the learned DSJ will appear for 5 and 6. The learned DSJ submits that It doesn't have instructions to appear on behalf of 5 and 6. The learned counsel for the petitioner shall file requisites for issuance of notice to 5 and 6 by speed post.
Yes, ma'am.
Requisites within?
Within 5 days.
Urgency will take 5 days.
2 to 3 days.
3 working days.
3 days.
Fixing early returnable date, postal tracking report will be placed on record. But if you don't say the date of examination, how we will know? List on 28th July.
Oh, like that. This OP number 3, Medical Council of India also didn't appear here. Although here.
Yes, the OP number 4, we are appearing, no issue.
2, 3, 4 he is appearing, na?
Yes.
The parties shall file their respective pleadings by the next date.
Item 42.
28 July.
Because we don't.
Council has been appeared for the response.
Waiting you take fresh notice. That's why. It serves no purpose of listing again and again. Mr. Parija, BC Parija for the appellant, he submitted that no one has appeared on behalf of the respondent. The other matters fixed, you can take it up.
Can you take up?
Yes,
I have come after having your 28 will come.
I'll intimate to.
That month is 20. Well,
Lords, this appeal is directed against the learned single judge's order. Let me just briefly state the facts.
Yeah.
Lords, I am classified. I was a non-whole-time director in a company. I am today classified as a fraud account, my lords, for certain loans which were taken by the company, my lords. And my lords, I was admittedly a non-whole-time director, not a non-promoter director. So I am classified.
Are these concepts do operate in company law?
Yes, yes, my lords. This is not actually, I am just stating as a matter of fact, this has no company law ramifications. This has primarily, your lordships will, just give me a minute, I'll come to that point. So, my lords, I am classified as a fraud account. Your lordships are aware regarding the master directions which RBI comes up with, which are under 35A of the...
Have got statutory force.
They are statutory force. So, my lords, normally, generally speaking, you are first classified as a willful defaulter. And then, my lords, you're also classified subsequently for... There are certain stages, which I would show the circular also. Then you're classified as a fraud account, my lords. My whole case, my lord, the sum and substance of the case is that I am being classified as a fraud account without giving any notice. Now, my lords, this question fell for consideration before the Honorable Supreme Court.
How Supreme Court?
Yes, my lords. That Rajesh Agarwal, So, my lords, in SBI versus Rajesh Agarwal, the detailed paragraphs, I'll come to that.
Yes, we will see that. Yes, that we can go further. What's the apex court see? What the apex court said in just 3 lines in Brandy's statement, make that statement.
Yes, my lords.
3 lines.
The Supreme Court says in Rajesh Agarwal that though the circular doesn't say of audi alteram partem, but that is something which is ingrained by virtue of Article 14. Despite non-presence in the circular,
you should be read into.
Yeah, simple, my lords, one-liner, that's the whole essence. Now, my lords, what happened was, the argument before the Supreme Court was that it suffers from the vice of arbitrariness, and also a challenge was that it was ultra-virus. That argument was also taken. But the court didn't get into ultra-virus. The court said, I'll supply this to the provision of the circular and
you should be heard in the matter.
Correct, my lords. That is the long and short part. Admittedly, now let's come to the facts, my lords.
Yes.
There are paragraph after paragraphs in this judgment, my lords.
You have said that. We have no reason to doubt your worship.
No, I'm...
Yes. Now,
yes, ma'am.
When were you when your account was classified as a default account, what do you call that?
My lords, it is called a fraud account, my lords.
No. First one, default account procedure is there. No?
That is willful default, my lords.
Default.
I am initially classified as a willful default.
Date.
Lordship is
that was yesterday?
Aye. Lords, I have a short list of dates if I can tender that.
Well,
data sets. Yes. Okay.
Yes. That's the only point now.
Yes.
What is it?
That's the only point.
My submission is that before that, notice has been issued to him and action as per the Surface Act has been.
No, but the notice was to treat him as
in respect of the fraud, that is not with me.
Then,
my lord, in the master circular, that was not there at that point of time. My submission before the honorable single judge is that at that point of time in the master circular, that is not there, my lord.
When you declared him? Date of declaration?
In 2013, my lord. 19 to 2013, my counter affidavit. It is yet.
So your contention is that Rajesh Agarwal principle comes to the date on 27/3/2023. But since it has been otherwise it would have been struck down.
Yes, my lord.
Your entire
not struck down. What the honorable appellate court said.
Otherwise.
Otherwise.
Which the word otherwise and everything.
Yes,
my entire articulation changes.
Yes, ma'am. 2/9/2013, ma'am.
Circular is dated.
This circular, which circular they have annexed, that is not the circular, your lordship. I have brought the circular of 2011.
That's the circular which is 1/7/2016.
No. 11, there is a circular. I have brought the circular, your lordship. I am supplying. 11, there is a circular.
We are just asking, as on the date.
My lords, I am going by what they have stated in the counter affidavit.
We have understood.
I have honestly stated that is not there.
Question is, was there such a circular when the account was treated as fraudulent?
Yes, ma'am.
It was there.
Yes, ma'am.
If it was there, then apex quotation applies.
Yes.
Otherwise also apex quotation.
By my submission at that point of time, that is not there.
No. Why it will apply, I tell you. Take out 78 Supreme Court, 851. Mahindra Singh Bill.
Yes, I have it.
In all law.
Yes, anything which is civil consequence.
KRISHNA, yes, my lord. In all laws, the court should read the principles of natural justice into.
Yes.
Unless law itself says otherwise.
Yes, ma'am.
And these are held to be instruments of law by the apex court, at least in half a dozen judgments.
Yes, ma'am.
Because they are relatable to Banking Regulation Act, Reserve Bank Act, so many regulations, etc. Therefore, they have got statutory proof. Now, the short question, this is number one. Now, had it been given, opportunity was given. What the apex court said? Apex court remanded the matter in that matter?
No, I'll tell my lords. What had happened was there, my lords, the court, no notice was given. So court said then
what the court did,
the banks would then give them a notice and then take subsequent action, whatever they're entitled to in law.
As per the circular, the bank has to intimate about the fraud to the RBI.
Because
and RBI has to publish in the website, in their website, that relating to the fraud. It is not that directly the bank will do this.
No, it's all right. But branding a person as a fraudulent man,
yes, ma'am,
will have many repercussions. Yes, small it is.
I do admit, Your Lordship. I do admit.
Defaulter. A man may be defaulter for innocent reasons. Is it not? Who is the borrower? Whether the company is the borrower
company is the borrower, my lords. And what happened was, company is the borrower, he is a guarantor and he is a full-time director, ma'am. It is their document.
Let me sign the loan documents.
Yes, ma'am.
No, my lords, I have not signed any loan document. That's wrong, my lords. It is completely wrong. Nothing is stated on record in the counter affidavit.
Yes, my lord.
Let me just complete.
Additional affidavit.
I will just, let's 1 second. I'll just say.
Like that. We cannot give so much time to you.
No, I'll just.
We have understood your
all right. Then
and you will be given, we are just saying, pattern we are saying now.
Yes.
We are paternalistic way. We are saying what we want to do. We will remit, set aside that treatment of the account as being fraudulent account. You follow the apex court decision in the light of the circular.
Yes.
And do it in a time bound.
Yes, ma'am.
Over. What is that argument? Continue.
I am not disputing. I am not disputing.
I'm telling you.
What my Lord's brother is saying that I have, by way of additional affidavit, I filed the every documents signed by the that petition.
Right. Shorn of the thickness of the paper book.
Then you are supporting him. He said that nothing is in counter. You support him that you are filing by additional affidavit.
No. In counter, I have stated without document, but in additional affidavit,
that time serious jokes also, apart from serious fraud, serious jokes.
Kindly be said. Shorn of thickness of the appeal paper book, the short question of law that arises for consideration of this court is as under. Can the banker, like the respondent hearing, brand its bank account as the fraudulent account unilaterally, that is, without giving an opportunity of hearing? Question mark. This question is no longer res integra in view of apex court decision in that statement of India versus Rajesh Agarwal. AR 2023 SC 185. First. Next paragraph. Where is it? It has been ruled that bank cannot do that. Cannot do that. More particularly when the principles of natural justice are treated as being part of Article 14 jurisprudence, the Constitution. First, it hardly needs to be stated that the apex court in Mohinder Singh Gill versus Chief Election Commissioner, AR 1978 SC 851, has reiterated the legal position to the effect that any action to be taken under a statute or instruments of statute adverse to the interest of a citizen, person, can be taken only after complying with the principles of natural justice, unless a departure is indicated in such instrument itself. First, next paragraph. Much discussion on the factual metrics of the case is not necessary, in as much as it is the fairly admitted position of fact metrics that
the bank account of the company in question, of which the appellant happens to be one of the directors, was certified as a fraud account while the note dated 19/2/2013. Fraud was not in 30. First time. Learned panel counsel appearing for the bank vehemently submitted that mere violation of principles of natural justice would not be sufficient for granting indulgence in the matter, indulgence in the jurisdiction. And what is required is the demonstrable prejudice. First, he also made submission in justification of the reasoning of the learned single judge on which he constructed the impugned order. First time. Next one. Learned senior advocate appearing for the appellant director submits that fraud has serious implications in any civilized jurisdiction, and therefore such an extreme action cannot be taken without giving an opportunity of hearing to his client. First, he adds that learned single judge missed the point of law indicated in Rajesh Agarwal, and that is how an error apparent on the face of the record has crept in, warranting interference of this court. Next one. Having heard the learned counsel for the parties and having perused the appeal papers, we are broadly in agreement with the submission of learned senior advocate appearing for the appellant. First, our view is supported by what the apex court said in Rajesh Agarwal, Supra. First, we need not say that the bank, like the respondent, is an instrumentality of state under Article 12 of the Constitution of India, which is that judgment, which said that bank is an instrumentality of state. Take it from Google. In the light of apex court decision in Gujarat State Finance Corporation versus Lotus Group of Hotels. And therefore, its actions have to comply with fair standard procedures. First, branding a person or his account as being fraudulent will have serious repercussions in a society like ours. First, such an extreme action can be taken only in after complying with the principles of complying with the requirement of principles of natural justice. First, this aspect appears to have been missed in the impugned order, in its right sense. First, in the above circumstances, this appeal is allowed in part. The impugned order of the learned single judge is set at naught. Appellant's WP number. What is that number?
12394 of 20.
So is allowed favored in part. First, the action of the bank dated 19/2/2013, whereby subject account of the company borrower company
is declared as fraudulent account is set at naught. It is open to the respondent bank to take the action afresh
And only
in the light of our observations here in above, and also keeping in view the apex court decision in Agarwal, Rajesh Agarwal, as also the extant RBI guidelines.
Madam, only I pray in respect of the petitioner, where your lordship has stated in respect of the company.
No,
because individual they are.
It is in whose name?
In account
is in company's name.
Yes, ma'am. If that will be quashed, then I have to give notice to all, my lord.
Okay.
In respect of the petitioner only, your lordship, there.
The benefit of,
Can I just show one page, my lords?
the benefit of this order is confined to the appellant
Only, my
before this court.
on
Page
Only
103, my lords. Just page 103
Of the appeal memo.
of the appeal memo is the central fraud registry, my lords. There it is assigned, a fraud number is assigned, Kwame, under the heading of the company, which is the Hon'Ble alloy. So that's why I'm telling fairly, my lords. It is, my lords, I am not very sure.
Who does this?
My lords, this
That
is the
RBI,
central fraud registry of RBI means.
Of RBI.
RBI.
Whether RBI is a party here.
RBI is also.
RBI is also party.
Yes,
no,
RBI is for RBI.
no notice has been issued in the.
You take all steps
I cannot.
to remove. No, we direct you now.
Yes.
That entry is made at your instance.
No, my lord.
Yes, my lords. It's
Our instance.
That's
Possible.
That's all.
Your argument is it's impossible without your instance. It could be. You argued that you report to the RBI.
Yes, I have.
That's your argument.
Yes.
What is that
My
register?
lords, it is called Central Fraud Registry at 103 of the
entry made in relation to the fraudulent
entry in relation to fraud qua the appellant with a fraud number so and so.
I'll write down it.
Yes.
Which is that page number?
It is page 103, my lords.
First column, in first column that is there.
So it is prior to merger.
Yes, ma'am.
Yes, my lord.
Prior to merger with PNB.
Yes, ma'am.
Yes, my lord. So
It
this
is
was
prior to-
United Bank of India.
At that point of it is United Bank.
That's why, my lords, may kindly see.
Just give us a moment.
Yes.
Let us get to that page.
Yes.
Annexure 8.
The subject, you can write it. The subject entry in query panel for Central Fraud Registry, bearing number. What is that number?
It's called, my lords, UDB
1404.
UDB
1404.
Then hyphen double.
Yes.
I think 140, then one another.
Yes,
Yes, ma'am. That is in respect of the entire company, madam.
Therefore, we'll clarify.
Number.
Entire company. Next column, Mohavadi Alloys Private Limited.
Company. No, we will clarify that.
Yes, only clarify. In respect of it.
So and so. Now, what is this date?
My lord, this it is not they have not put
It's
the
perhaps a running account.
Yes.
So my lord,
Read Annexure A 8 is masked for the appellant hearing. Till after bank accomplishes the process indicated above.
Yes. The entire process, your lords, time bound, your lords.
No, if you want to do, you do it. Why we should not take?
You do it by tomorrow. Difficulty. By midnight, no difficulty.
That's all. Little linguistic change it undergoes. This is the understood the order.
one thing, lest there could be an error in the order, I thought I must say, because my lords, my learned friend said 19 to 2013.
Date may not be correct.
I may not be correct because I showed my lords the Central Fraud Registry. So if your lordships would see, it says UDB so and so 15.
That is United Bank.
No, I'm not saying that. It could be ideally of 15.
On the 15 he is highlighting because the number is.
Maybe we have intimated it in 13 to the.
All right, then my lord.
RBI.
Their state. Then I have no.
We have intimated it to 13 in RBI to the RBI.
Then we will not say the date at all.
Yes, my lord.
We'll say subject certificate.
Only in my submission you have
number.
That's correct.
Only my submission that may be recorded because that is I have counter. I have stated.
Necessary. You have made. I mean, your point is well recorded.
Yes,
but making a mistake in date unnecessarily makes you will be put to embarrassment also.
And tomorrow his client will ask him why you did not indicate what he should tell. Anyway,
This things
may not be necessary. Just one question. Little frame it undergoes. Yes, our notes.
थोड़ा सार को ब्रीफ रखिबे ना स्टाफ मारी की रिसीव करिवे
Is right that Mohinder Singh Gill says that anything which has civil consequences, you are put to it. Simple. That's what Rajesh Agarwal also notes.
That is the settled person of law. I cannot go beyond it.
We should appreciate his tall, even he stood tall in the bar also.